So we invited Holger Schmieding, who is chief economist of the Berenberg Bank in Hamburg and London, to give us an insight on all of this. So Holger, very happy to have you and to tell us, where are we?
Well, thank you very much. You've posed a great question. Will Germany's court one day stop the ECB? And will this story ever stop? I don't think that the court will ever stop the ECB, but the court may, that is at least a serious risk, the court may eventually set limits to what the ECB can do according to the court. And I'm afraid in Germany, there will always be, for the foreseeable future, be people who will challenge every significant action of the European Central Bank at the German court. So you could say this kind of noise will probably not leave us. What's the background for all this? A year ago, on the 5th of May last year, Germany's court caused a stir by a verdict on the ECB's standard pre-pandemic asset purchases. The court basically said three things. First, the European Central Bank exceeded its competences by adopting its standard asset purchase program without paying due regard to the side effects, or at least without making clear that it had weighed the effects and side effects correctly, proportionality principle. Second, the German court said that the European Court of Justice, by rubber stamping these ECB asset purchases, had done so in a way that, quote, is not comprehensible, unquote. Third, the court said that the German government and parliament had violated the German constitution by not holding the ECB to account. These were really strong words. That one court says what the other court has said is not comprehensible, for instance, is really strong. Well, it all ended amicably. 3 months later, the ECB supplied some extra information about its internal debates at the Bundesbank, which forwarded it to Berlin, and Berlin said that this proves the ECB had indeed weighed the consequences, effects, side effects, whatever, of its actions adequately. And 9 days ago, the German court rejected a new challenge against this standard asset purchase program, and by basically saying, okay, what Berlin has done is right, and now it's all okay for this standard asset purchase program. Before I discuss now the outlook, let me make a disclaimer. I'm highly critical of the initial German court decision, so I'm not sure whether I'm a fully detached observer in that sense. I'm not a legal expert. I sort of see a legal point in what the German court had said. European institutions have only those competences which member countries have explicitly granted to them. Ultimately, the German court is probably right to say that it needs to play a role in judging whether a European action is within the realm of what Germany has ceded to the European level. And for a long time, the German court seems to have itched to make this point. And in the last big decision of its then outgoing court president, it finally made the point. However, in my view, it shows the absolutely wrong issue to do so. Because my impression, reading the German court verdict and previous court verdicts on related matters, the court subscribes to what you could call an outdated understanding of monetary policy, to an outdated narrative that is unfortunately quite prevalent still in Germany. You could call it a simplistic monetarism, where central bank money supply drives inflation, period. This simplistic version of monetarism pays no due regard to the critical role of the demand for money, well, which is often sufficiently stable, but not in unconventional times, let alone in crises. And it neglects the transmission mechanism of monetary policy to the real economy and inflation. This understanding, simplistic, outdated, is quite prevalent in the German debate, I must say. Not only in the German debate, but it's very strong over here. And it's often articulated by those who wrongly predicted for the last 12 years that ECB unconventional policies would inevitably lead to high or hyperinflation and or currency collapse. Unfortunately, these chaps don't seem to see that their views are based on what I would say wrong economics. The court, for instance, bemoaned that the ECB policy, the unconventional policy, asset purchases, to lift inflation towards the target, that this lowers financing costs for governments and may encourage too much borrowing, that it lowers the yields for savers, that it has distributional effects. The court calls this side effects of this ECB action, which interfere with the realm of economic policy as opposed to monetary policy. In my view, that's not the right way to describe it. In my view, these things are simply the inevitable transmission mechanism of monetary policy. To raise inflation back towards target, the central bank must encourage economic agents to spend more and save less. These are not side effects, that's just what's needed. But again, the German narrative, or at least the narrative prevalent in parts of the German debate, neglects these things. And the court does seem to have implicitly some sympathy, or seems to be somewhat informed by this wrong negative narrative, in my view. So I'm afraid that the issue, as it comes to the outlook, is hence not crystal clear. We have, as far as I know, 2 cases against the ECB's anti-crisis program, the PAP program, pending at the German court. One from the parliamentary faction of the right-wing AfD, dating from August last year, and one from 16 claimants, including some repeat claimants, dating from March 2021. Their key arguments are that this pandemic crisis program, these emergency purchases, violate the limits to asset purchases that the German court had more or less spelled out in previous verdicts, and that this crisis program primarily serves economic policy, not monetary policy. The issues are a bit problematic if you sort of take the narrative that is often heard in Germany and that seems to have at least some influence on the arguments of the German court. There are problems or potential problems, or you could describe them as potential issues. The PAP program is indeed large. Roughly speaking, the ECB is buying more or less the entire net issuance of governments in the Eurozone at the moment. Those who sniff monetary financing, in inverted commas, can make some hay out of that. And the PAP is and must be, in my view, deliberately flexible over time, jurisdictions, and types of bonds. The purchases may deviate from limits for standard pre-COVID asset purchases, capital key issuer issuance limits, and the like. These could be potentially serious issues for the court. However, the court does see itself as a pro-European institution. It did not, in May last year, rule that the standard asset purchases violated the prohibition of monetary financing. It really shied away from the big bombshell. Now, the court also, in the relevant second Senate, has a slightly different composition. For instance, a new head of this Senate. The court has very much acknowledged the emergency situation of the pandemic, and the court had been taken aback last year by the strong criticism it drew from almost everywhere, except the claimants, of course, the very strong criticism against its May 2020 verdict. And the court was probably quite surprised by how eager almost every mainstream politician in Berlin was to get this under the carpet as fast and easy as possible, that basically to go through the motions, but ultimately let the ECB what it has to do and just go through the motions of what the court has required without in any way Berlin wanting to constrain the ECB. That suggests to me that the court probably will not want to rock the boat badly in its upcoming judgments on the pandemic emergency purchase program. I called the court today. They couldn't give me any timeline. I must say, if you know more about that, please let me know. It's work in progress, the court said. So the outcome for these 2 cases is in a way open. In the past, the court has often ruled when it came to critical European matters that it's okay as it stands, but please don't go much further. De facto setting limits for future developments without ruling that what has happened in European integration already is beyond the bounds of the German constitution. And hence there is a risk that the court may eventually set some limits to the flexibility of ECB asset purchases. It may set sort of de facto limits to for how long the ECB can continue its pandemic emergency purchase program. And at least it's possible, I would not like that, but at least it's not possible that the risk of the court trying to constrain, not stop, but trying to constrain the ECB somewhat would rise with, say, the deviations from the capital key in ECB asset purchases over time, or rise with the length of time that the ECB continues its PEP program beyond, say, the period when the Eurozone economy is back to the level of GDP that it had pre-pandemic. I would think, and I do think, based on my understanding of monetary policy, the court could just basically say what the ECB has done so far and is doing at the moment is exactly right. Look at the results. Financial stability has been preserved, price stability has been reserved. But as an observer of what the court has done so far, I at least see a risk that there may be in some future court verdicts explicit or implicit limits as to what the ECB can do in the future. And to round it all off, of course, there's also a separate challenge at the German Constitutional Court against the 750 billion EU recovery program, but that would take a different session to discuss that. There, I'm fairly hopeful that the court, despite qualms, will let the financing of that package go through. Thank you.
Thank you very much, Holger. Very, very good to have this point and to talk about these limitations. To your mind, these limitations, it's always about the conflict between a central bank that needs to be 100% efficient and in a crisis moment, and the conditionality on the other side that some want to have. But if you have conditionality, you won't be 100% credible. So is there a risk when there are limitations that the court will give that the efficiency will not be enough in a future crisis moment?
Yes, I would say there is a bit of risk. I don't want to overemphasize this point, but there is a bit of a risk. And the risk, in my view, largely comes from that, as I see it, the court has, of course, they are legal experts, they're not economic experts, has what you could say is somewhat limited understanding, in my view, of what monetary policy is, and especially of what monetary policy ought to do in unconventional situations, in non-textbook situations. And hence, I do see these risks. For practical purposes, I see that Europe has a great tradition of dealing with legal obstacles. Ultimately, Europe has always found a way so far to get around legal roadblocks thrown in the way by whatever quarter. But there could be some noise, and there could indeed, if you have to find a way around a legal roadblock, there could be some temporary loss in efficiency in a policy response. Yes.
Mm. Another very question, but that's maybe just a quick answer, a feeling on your side. May there be a situation where the ECB won't have to go this way anymore, but go back and reduce their engagement?
Well, I hope that we will be going towards much more conventional times in the future. I'm fairly optimistic about the economic outlook beyond the pandemic. I look for stronger productivity gains. I look for stronger gains in per capita GDP. I look for a partial return to the old normal of somewhat higher real yields, somewhat higher nominal yields, somewhat higher central bank rates. And as a result, I look for a return to times when the standard policy, interest rate policy, will be back in action again from, say, 2023 onwards. And that would probably diffuse the tensions a lot, of course, until, hopefully not too soon, another crisis may require unconventional means again.
Mm. You've been talking about the German mindset or the German narrative. And we are trying to prove that there's not only one German narrative.
Indeed.
And there is, I mean, there are very diverse people. I don't know, you said you're not a lawyer, certainly, but I remember looking at the people that the court consulted at the time at some of these important moments. You weren't astonished that the result was like it was. They invited mainly orthodox economists, German ordo-liberal economists. And then it's not astonishing that the narrative is not different from this old storytelling. Do you know, or have you ever an idea of who is choosing that? Are they freely choosing the people they are consulting, or is there someone checking this, or could someone tell them that maybe that's not the modern kind of economic policy making?
Honestly, I can't give you an answer on that. Who at the court is choosing those? They have, of course, asked relevant people, but indeed, it has also struck me that of the various German narratives that there are, that is somewhat old-fashioned. I wouldn't use the label ordo-liberal. I just like ordo-liberalism for a lot of other things. So I would use a different label, but that this simplistic monetaristic view, yeah, money supply equals inflation, that this has probably been a bit overrepresented, and that it would have been much better for the German court in a decision which is, when it comes to the economics of it, a European one, not a German one. If it had consulted, say, European or global experts on monetary policy, rather than basically having for a German legal judgment, largely consulted German monetary experts. So I wasn't quite happy with the choice of people whom they had.
Talking about the Karlsruhe and the Bundesverfassungsgericht, everyone now has in mind, and that allows us to transit to the next discussions. There was a recent ruling by the court on climate and the responsibility of for next generations, and to take that into account, and so on. I mean, talking about these issues of central banking, it's also about having future generation, also talking about future generation. And then yesterday there was someone, Shahin Valais, who said, it's interesting that inside the Bundesverfassungsgericht, there are the two senates, the two parts of them, and one seems to be the one who's leading the economic and the ECB ruling is more a conservative one, and the other one was the one doing the ruling on climate, which seems to be more progressive. What is your take about that?
Well, it's difficult to put labels like that on it, but indeed the second Senate probably, at least the old one, under the old president, and without the new joiner, was probably on these issues on what you could say a bit the conservative side, in most cases with good arguments, just in my view, not on the monetary policy case. And now on the climate change issue, indeed, the court surprised many by its, you could say, wide-ranging interpretation of the Constitution, which of course is very interesting, but from which you can derive a lot of other things if we need to take much more into account explicitly what will happen to, say, young people 20, 30, 40, 50 years into the future, then we on many policy issues, such as pensions, possibly also on preventing financial crises and whatever, and things that could have longer-term scarring effects, we could be in a different debate on many issues than what has recently been the debate at the court.
Okay, thanks a lot. Very inspiring, and I mean, we would like to ask some of these questions also to Isabel, but the questions will be asked by Laurence then in the next session. Just to thank you, Holger, to have joined and helped us to understand what the state of things are concerning the ruling.